Our next panel is a panel of one. It's a mock sentencing workshop presented by retired federal judge Emcee Gertner, who's currently a senior lecturer at Harvard Law School. Judge Gertner served as the United States District Judge for the District of Massachusetts for 17 years. She is widely recognized as a leading, prolific, innovative, and insightful expert on sentencing, among many other legal subjects. She's received numerous awards for her judicial accomplishments and has spoken and written extensively, including her autobiography entitled In Defense of Women, Memoirs of an Unrepentant Advocate. Available on Amazon.com. In the criminal justice space, she is a rock star. So I give you Judge Gertner.
Thank you. So I had a plan here, which I'm sort of not. No, I have one.
Okay, great.
I could have more. As my husband describes now, that since I'm off the bench and I can speak, he says, I've never met a microphone that I didn't like. And this, of course, is completely true. I do want to say a few things before I go into this sentencing exercise, because I've been scribbling all morning. And I want to say something about the 800-pound gorilla in the room. The 800-pound gorilla in the room are the sentencing guidelines, right? We are talking about dealing with a system that is 40 years old, the federal sentencing guidelines, which were enacted at a time of moral panic, which is to say crime was rising, and it's since declined, before we knew about mass incarceration, before we knew about the impact of things like criminal record and the crack cocaine disparity on racial disparities, and before we knew that we were creating a culture of mass incarceration. So it's not a surprise that when you look at the factors, the statutory factors that are listed that frame the federal sentencing guidelines, rehabilitation is down the list. It had been discredited. To all intents and purposes, and I just want to do the big picture and then we'll get to more of the details. These diversionary programs, these phenomenal diversionary programs, have been crafted in the interstices of a very troubling system. And that's part of the problem. That 1% of federal offenders are going through diversion programs. The prosecutor, for the most part, except for the extraordinary program in the Eastern District of New York, is the gatekeeper. The program doesn't include people oftentimes with criminal records. That has a racial disparity influence, because the people who came into my court invariably had been picked up. They were in communities that were policed a great deal. So if criminal record is what determines whether you get in a program, it's going to have a racial disparity to it. Not including violent offenders, one of the things that I'm doing now is I'm writing a book about the men I sentenced, whom I am meeting. And they are almost invariably those who were victims of violence, witnesses to violence, or perpetrators of violence, and often all the same thing. So when you exclude from these programs individuals who, quote, are violent, you are oftentimes excluding the people who need them the most. It almost feels like sometimes when we talk about diversionary programs, we're talking about who are the deserving poor, if you remember that from decades and decades ago, and who are not. But I want to talk today, and to some degree, diversionary programs, which are fabulous and which have proliferated, they came about in the interstices of mandatory guidelines. You could have reentry courts because essentially the prosecutor didn't care once the guy had done time. You could have possibly pretrial courts if the government bought into it. But these were in the interstices of an otherwise not particularly fair system. And I know I presided over it for 17 years. What I want to talk about today, I have a hypothetical. This is the way I teach sentencing to other judges and teach sentencing to my class at Harvard and taught at Yale the same way. And the hypothetical, we'll go through the hypothetical, and ask the question of what the guideline sentence is, because unfortunately we have to begin there as judges in the federal system. And that, of course, skews the discussion immediately. And then we'll ask, well, would you have this person in your diversion program? Is this person who would qualify for your diversion program? And then I want to have a conversation that is not just about diversion, because maybe he doesn't fit in your diversion program. Maybe he would get, or she would get, probation, and the insights that we've learned from diversion can bear on what probation would look like. Or even if you have to sentence him, maybe the insights from what we know about these diversion programs would bear on ordinary sentencing. So I want to talk about diversionary programs, I want to talk about ordinary probation, and I want to talk about ordinary sentencing. Because if we don't take these insights and apply them to what is the 99% that are outside of diversion, we won't be doing much. So, first slide. You're running it, I'm not. So this is about teaching sentencing. And it's a little weird to be getting to this level of detail, but that's what they wanted me to do, so I'm going to do it. Okay. So pre-guidelines, this is so boring, but I'm going to see if I can spice it up. I was a lawyer at a time when sentencing was completely discretionary. You could make any argument to the judge. Sentences were between 0 and 20 years, or 0 and 15 years. The judge had complete discretion. But of course, that meant, and there was no appeal, that meant that there were differences from one judge to the other. There was no question about it. And we taught judges sentencing. This was not me so much, but at Yale, there was a program for state judges who had no guidelines and had no standards. And you'd have them come together and talk about typical cases and see if we could come up with consensus about what to do in typical cases. In a sense, it was like a clinical approach. Doctors have checklists, for sure. But doctors also talk to one another about what the best practices are in an individual case. And so to some degree, what we were doing with state judges was asking them to look at the cases and talk about what should happen in a clinical way. After the guidelines, I saw the way federal judges were taught about the sentencing guidelines, and there's this 800-page book. And they were only taught the 800-page book. And by the time you finished those courses, all you knew about was how to make the computation. You've lost all sense of who the person was. I know, you lost all sense of who the person was. After Booker, again, I'm getting boring here, the guidelines became advisory, and so judges had discretion. So to some degree, I would love to talk about how to use that discretion, how to inform that discretion in ordinary sentencing, not in diversion programs even, although that's wonderful, but in ordinary sentencing. Judges are still, as of 2 years ago, taught the same way. They're taught the guidelines, they're taught how to apply the guidelines, they're taught how to do the math, and then there's the last slide that says, of course, they're advisory, goodbye. And we wonder why many judges are lost. So as I said, there's an alternative model here where we look at cases, and I'll show you one now, and we ask what's the best alternative in those cases. There is what I call sentinel review, which is what I'm doing in the book that I'm writing. Sentinel review happens in hospitals when there's a death. And all the doctors get together and say what went wrong. And in a certain sense, the book that I'm writing is about what went wrong. Because I'm interviewing some of the men that I sentence. It's not particularly scientific, it's largely anecdotal to say what went wrong. We don't ever think about sentencing in the what went wrong way. And then I want to talk about typical cases. Next slide. So this is the case of Duke Beasley. It's really just a case that I chose because I thought that it would deal with both the question of diversion, who gets diverted, the question of ordinary probation, and the question of ordinary sentencing. Next slide. I can't stand the lack of control over this, but that's okay. Really. Okay, 21 years old. So he's in the category, in the Eastern District of New York, 18 to 24, 18 to 27, emerging adults. And anyone who has raised one knows, particularly boys, that they are crazy. Just crazy. There were 3 bank robberies, and look at the dates carefully. November, then one in January, and one in February. 3 bank robberies. He was given pretrial release, which was interesting, after a month in prison, and he pled guilty. Next slide. The robbery was, as we call it, a note job. There was no gun. He walked in, he stuck his fingers in his pocket and said, stick him up, essentially. It was a die pack, as he walks out covered in the die pack. Next slide. This was a note. This is a robbery. Do not say or do anything. Fill the bag with $50 notes and $20 notes. I have a gun in my right hand. Hurry up. I had one case in front of me where the bank robber wrote the note and then he misspelled something. So he crossed it out, scrunched it up, put it in the garbage, and went on and wanted to redraft his banknote. And that note was what got him prosecuted. Then there's another one who's walking across the street and the red die pack explodes. Next slide. It was not the Italian job, which I loved. It was not the Italian job. So the first bank robbery, he wore a plastic mask and sunglasses, stuck his finger in his pocket, then he discarded the mask and the sunglasses in a porta potty, where they were covered in the dye from the exploding die pack. Next slide. The second robbery, he wore, which was, again, only months later, he wore a ski mask, sunglasses, again recovered in, this time, a recycling bin. Again, he stuck his finger in his pocket pretending to have a gun. In the third robbery, similarly, they never got the stuff that he was wearing, no gun, and stuck up a bank. Next slide. So the victim impact. Now I'm going to give you the guideline approach, right? Just to show you where judges have to start. How much did the bank lose? The seriousness of the offense is determined by the amount of money lost. Say what? It's happenstance how much money was in the tray. Could have been a good day or bad day. That doesn't affect the culpability of the person. It's the happenstance of what's in the tray. But under the guidelines, the amount of money you stole determines or frames the guideline number. Victims, clearly that was an issue. You could have your finger in your pocket, didn't matter. The victims, the tellers were certainly scared. There's no question about that. Guideline calculation, God, is this boring. I haven't done this in years, so bear with me. The base offense was 20, driven by the amount of money that happened to be in the goddamn drawer. A financial institution is plus 2. It's a federally insured institution that was plus 2. Who cares? The offense level for robbery 1, robbery 2, robbery 3 were 26. For various reasons, the overall offense level is 26. Slow down a little bit. Okay, next slide. Okay, next slide. Okay. Am I boring you? Next slide, please. Criminal record. The guy had no criminal record, which is astonishing for a juvenile, right? No juvenile record until March of 2022. There's a robbery very similar to the others for which he received 9 months. He was 20. That got him to a criminal history 2 because of the amount of time he had done. Next slide. So now let me tell you a little bit about his background. We have the criminal record, criminal history 2. We have the offense level. And let's fill in to the extent that we can, fill in the picture here. Pretrial services indicated that he failed to attend substance abuse, failed to submit to alcohol testing. He was nevertheless allowed on pretrial release. He was born premature, was small for a man, 5'6", weighed 120 pounds. Later on, we'll talk about how he was ridiculed in school because of his small stature. At 15, he fell from a 15-foot statue, was unconscious for 26, yeah, I'm law-based, I can't quite get it, was unconscious for 26 hours and hospitalized for 4 days. He started drinking and using drugs as a freshman in college. When he was 19, his mother had a heart attack. He moved to oxycodone. He drove to California at 20 and committed the bank robbery. This is from the pre-sentence report. If it's sort of chaotic, it's because it's from the pre-sentence report. New slide. In other words, the pre-sentence report doesn't give you a narrative. You have to put together the narrative. Next slide. At the time of the fall, he was diagnosed with a generalized anxiety disorder, alcohol dependence, opiate dependence, marijuana use, executive functioning problems, cognitive inflexibility, et cetera, et cetera. In one sense, he was lucky that he had this evaluation when he was 15. Most of the men that I sentenced for crack were kicked out of high school, and there is no psychological record. May I say this for the white kids that appeared before me, oftentimes middle-class kids, when they got in trouble in their teens or early 20s, they immediately were at a psychiatrist. For the guys that I was sentencing from these, quote, gangs, they were discipline problems. So Mr. Beasley was lucky that someone evaluated something. Next slide. He was diagnosed with an adjustment disorder, depressed mood, opioid dependence, alcohol. This was while he was on pretrial release. He reported that he sleeps all day, covers his windows in plastic because he wants to prepare to go back to prison. He's already assuming he will go back to prison. He's attending mental health counseling as a condition of pretrial release. New slide. He is worried about being incarcerated again. At this point, the judge in me says, well, that was obviously not enough to keep you from doing this again. Sometimes I think of the things that I said on the bench and I'm mortified, right? In what are the situations you say, well, 9 months didn't work for you before, now we'll triple that and see if that's going to work. He was robbed at gunpoint by a drug dealer who put a gun in his mouth. He was then robbed at knife point. He was bullied at school. Mother and father were abusive. I don't know the details. Next slide. Again, substance abuse was building. From 9th grade, drinking, marijuana at 15, cocaine from 19 to 20, mushrooms, oxycodone after his mother's heart attack, snorting 7 to 30 milligram oxycodone tablets per day mixed with heroin, then heroin alone, Xanax 1 to 2 times per week. New slide. So substance abuse, trauma, no formal substance abuse disorder diagnosis. High school, graduates high school, but it's not clear what skills he graduated with. He had to transfer from one school to another because of the bullying. Currently unemployed, fired from a laborer job because of absences. He was using drugs at work. Next slide. The guideline sentence is 70 to 87 months. 70 to 87 months. Based on the offense and based on his criminal record. It was a 26-2. The guideline range was 70 to 87 months. Okay, and that's where a judge is supposed to start. And the question is whether that where you start is already drawing this case to imprisonment. And maybe it should. I don't know what others feel in this room. Already drawing you, presuming imprisonment, because the guidelines presume imprisonment. One of the things that the federal sentencing guidelines did is essentially increase the numbers of people who were going to be in prison. So what do we do with this next slide? Depart, you don't just ignore that, I'm a guideline nerd. Do you vary? Vary means do you go off the 70 to 87? Would you put this person in a diversion program? Could he go to a diversion program in your courts or in your jurisdictions? And if he's not going into a diversion program, what about ordinary probation? What should ordinary probation do for why do I need the blessing of the US attorney to come up with what I think is the appropriate set of programs here? Or if there's time, in other words, sentence, what do you choose? The problem here is it felt when I was on the bench that it was almost like you were falling off a cliff. If you couldn't make if the in-out decision meant in, the time was that. In other words, we didn't use the observations we've learned about adolescence, the observations we've learned about drug addiction, the observations about trauma to inform the length of the sentence. The guideline was 70 to 87 months because they're framed by the criminal record and by the nature of the crime. JSON is a tool that the administrative office has come up with to give judges a sense of the average sentences. But the average sentences are sentences in an era of mass incarceration. The average sentences are way higher than they would have been 20, 30 years ago. Is there something else we should look at? I'm talking too long, but keep going. So let me pause for a moment now, because I want to talk about what could inform what we should do here, apart from a diversion program, apart from ordinary probation and ordinary sentencing. So would this person, Mr. Beasley, qualify for a diversion program in any of the jurisdictions that you represent? Judge Salas, I have to call on you. No. Why not? Crime of violence with his finger in his pocket.
Right now, the standards we have, unfortunately, we have a diversionary program that requires the U.S. attorneys to buy in. So, Mr. Beasley with a bank robbery would not be the type of person that the U.S. attorney's office right now would accept.
Okay, so if you had to, forgive me, I didn't want to put you on the spot, but if you had to sentence him then, you couldn't put him in a diversion program, what would you do in terms of probation or time?
So, I mean, you're talking now.
I'm talking to you. I know. That's why I called on you.
So, listen, I would start to look at Mr. Beasley's case, and I would ultimately, hopefully, have a defense attorney that's already working the case, making sure he's getting help, making sure he's in some kind of program. I would want to defer the sentencing if he was doing well to make sure that he's on the right track. And I would want to, I would ultimately take everything I've learned from my diversion program into my general population, which is what I'm doing. And if Mr. Beasley was doing well, I would vary it lightly, try to fashion a sentence that, in my view, accounts for all of who Mr. Beasley is now, not just who he was then.
In a certain sense, you're doing what the SOS program is doing. You've got your own EDNY program for, what else? Does anyone here think that they could come into your diversion program, Mr. Beasley, or what he deserves? We need someone to call on people. That's okay. I'm not one. I just play one on television. You tell me the program again?
We're in New York City.
Yeah.
So we run alternative incarceration programs. Specifically, I'm at the Fortune Society. We're a large nonprofit in New York City. And I think that he would qualify for our program.
But a judge would have to buy into that in the
Would
way that
release
Judge
him
Salas.
into our monitoring, correct?
Okay. And that would entail what? What does the program
So
entail?
we have group and individual counseling, cognitive behavioral intervention groups. We have an outpatient mental health clinic, outpatient substance use clinic. We have emergency and transitional housing. So if he needed to be housed, we could do that too. So we provide a whole host of wraparound services that we could envelop him with.
Okay. Anyone else here? In the back there? I need a microphone. Or
Raise your
project.
hand.
I'll try to talk loud. So in Vermont, if this case went to the state court, I'll shout out to Vermont. If this case went to the state court system because this person
if he was adjudicated, thank you, he would probably get dual support from a probation officer and a Department for Children and Family social worker, and he would likely be referred to a restorative justice program so that all three groups would be attending to his needs and to the victim's needs at the same time.
Federal system has no youthful offender program.
Right.
Yes, hi. We need a microphone.
So Mark Osler from Minnesota, and in our state system, a simple robbery, the guideline sentence is 18 months stayed. So as you well know, if that case was taken federal, which you can do for a bank robbery, you'd probably have that sentence, plus someone might add in the 2 points for threat of death. So it'd be up to 87 at the bottom. So there's an incredible gap between the state and the federal.
Well, the gap, and that's another part of the 5,000-pound or 800-pound gorilla in the room, which is you go federal, and the very same human being is treated dramatically differently. Now, there are many more resources on the federal side. There's no question about it. But that prosecutorial decision totally changes the picture. I think I'm only raising these issues because I keep on wanting to make sure that the discussion is not focused. Forgive me to put it this way, but again, I'm no longer a judge, so I can say whatever the hell I want. It's like we're accepting the crumbs on the table. We're accepting the crumbs on the table. Important, however this conversation is, but that's not where the real hardships are. We're accepting in diversion programs in 1% of the cases is simply not sufficient. You had your hand up.
You spoke about varying. I mean, you were a very compassionate judge. This judge up here spoke. But there's so many cases where there isn't judges that are not going to vary. I mean, we can go to Texas and McBride, and we can talk about those cases. But if you read U.S. versus Kupta when Gleason was on the bench, he outlines maybe 20 cases. There was a young man, African American, comes in, guidelines would probably be 57 to 71 months. I'm recalling it off the top of my head. The prosecutor, they spoke about him at a commission, at an event like this. The U.S. attorney speaks, yeah, it's wrong, what's going on there? They go back, they 851 him, and now his mandatory minimum was 20. This was a guy, typical story, New York City, unfortunately, drug-addicted parents, petty drug crimes, as a prior 7 or 8 grams of crack, and he ends up with a 20-year sentence. There's not as many judges like yourself and the judge that
Judge
spoke
Salas, she's a rock star.
I mean, there's a lot of judges that are not varying, where they're taking these, and I spoke about the guy, Billy D. Williams, pleads guilty to life.
Right.
What defense attorney tells his client to plead guilty when your mandatory minimum is life? You might as well take a shot, right? And he serves 20-something years, Obama releases him. But that's not typical.
That's
you don't see a lot of judges doing
right,
that.
that's the bigger picture. And when you talk about not seeing a lot of judges, so to some degree, your diversion programs, even ordinary sentencing, crafting a new program, even writing opinions. I would sentence someone, but I'd write opinions, because as I said, I love to hear myself talk. But I would write opinions in part because I wanted to create a body of cases so that others could say, well, maybe in this kind of case, the note job, we should be carving out some kind of different rules. Maybe it shouldn't be just categorical. Let me, I don't want to take too much time, but I wanted to tell you to some degree where we can go for information. So there's the big structural institutional problem. 40-year-old guidelines, time of moral panic, not paying attention to racial disparities, and disparaging mental health issues, addiction issues, trauma issues, all of that. Now we're coming back from that. That's what an advisory system enables. But we're coming back from that in these diversion programs, which are only 1%, ordinary probation, which is not clear how many people, what the analysis of that is, and ordinary sentencing, where we have no models to get from the guideline sentence to a reasonable sentence. So other information, next slide. I participate with the Federal Judicial Center. Mark Sherman is here somewhere, and the Center for Law, Brain, and Behavior at Harvard and Mass General. And I teach law and neuroscience in addition to sentencing, knowing, by now I know something about neuroscience, but I knew borscht about neuroscience when I started. Why did I care about this? This program is sponsored by the CJHD, talking about justice and human dignity. We can't talk like that in our sentences. We can't say, I'm going to give this man probation because other countries would never have been at 70 to 87%. Because human dignity requires that I exercise my judgment with respect to the rule of lenity. I give him the lowest possible sentence I can. We don't talk in terms of normative issues like that, human dignity, justice. European courts do, we don't. But we can talk about data. We can talk about data. And that's how I got involved with the Center for Law, Brain, and Behavior. Next slide. I don't know what that is. It doesn't want to do it? Okay. Well, that concludes my presentation. What happened there?
What about the prosecutor?
What?
Does it matter what the prosecutor says? Should it matter?
In what?
In your sentencing, when you ask the question.
Well, of course it should matter what the prosecutor says. I mean, it's an adversary system. It matters what both sides are saying. But the issue here is what sentencing, unlike any other part of what a judge does, reflects what's the right outcome, what is going to make a difference in the world. And I can, is this totally, you're going to get it? Okay. So the Center for Law, Brain, and Behavior mostly is dealing with neuroscience. And we can show you, when I depart downward for an addict, or when you put an addict in a diversion program, when the guidelines were first promulgated in the 80s, we were told that addiction was not ordinarily relevant, because addiction was seen as something that somebody was, intended to do. Neuroscience now lets us know that that's not true. Maybe the first drug was an intentional one, or there's a genetic component and an environmental component to drug addiction. But at a certain point, it is no longer willful, intentional behavior. Neuroscience teaches us that relapse is part of the problem as well. And again, this is not because I'm a touchy-feely liberal, and I am. This is because the data shows that. Next slide. Well, now we're talking about adolescent brain development. We know that adolescents are different, not just because I raised, 2 boys and I can tell you how lunatic they were, but because you know from neuroscience that the adolescent brain under 18 and 18 to 27 is different. This information doesn't help us in the individual case, but broadly speaking, we know we're dealing with a population that can change and does change. Next slide. Self-desisting misconduct, the misconduct desists with maturation. This goes to if we did nothing, some part of this group will simply age out of crime. The men that I have interviewed, I can't tell you how many times they have said this to me. They'll say, I don't know who that person was. I don't know who that guy who was involved with crack and gangs was. I don't recognize him. Next slide. Again, violent crimes, property crimes, all decline by a certain age. And yet this is the constituency, 18 to 24, 27, that we are sending away for the kinds of time that we have been doing. Next slide. This is my favorite slide. This is the example of why we know that adolescents and young adults are different. Teen set his armpit hair on fire, causes rollover crash. This is not who knows what this person is? This is the classic. Next slide. We have a white paper from the Center for Law, Brain, and Behavior dealing with late adolescence to be able to sort of summon this kind of information so judges and lawyers can make use of it. I just put that up there. Neuroscience of trauma. Judge Bazelon, many, many years ago, 30, 40 years ago, talked about rotten social background, essentially. He was mocked for talking about traumatic backgrounds. It was mocked in West Side Story, right? Rotten social background. Well, we know that trauma has an impact on the brain. We're not just speculating. Next slide. Toxic stress has an impact on children. It affects, it leads to cognitive deficits. It leads to autoimmune-related disorders. It leads to other behavioral problems. Trauma is not just, well, he's upset. Trauma has an impact on the brain. In fact, there's one of the people who speaks in my class, Dr. Kerry Ressler, who works with Dr. Capua Moreland, said that when he was studying trauma in Atlanta, Grady Memorial Hospital, he discovered that more of the people he was treating had PTSD than were the returning veterans from Vietnam. Trauma matters. Next slide. Adverse childhood experience is one of the worst slides in the world. Keep going. This is an ACEs pyramid. You all know about ACEs. Next slide. Adversity impacts development. The brain looks different for people who have gone through trauma. Next slide. The neuroscience of addiction. I was talking about that a moment before. Next slide. I mean, the brain of an addict, a long-term addict, particularly one who started at a young age, looks different. And that looking different has an impact on all aspects of their life. Their ability to inhibit, their ability to seek rewards, their memories, drug memories are oftentimes, memories that come to them that lead them to continue to go through drug-seeking behavior. Next slide. I'm not going to explain to you the rest of it. It is not, quote, choice. On some level it is, but there's a genetic predisposition. It's affected by the environment. It's affected by other psychiatric conditions. And so drug addiction is an issue. Next slide. Genetics, trauma, social risk factors, environmental issues, how early in your background you started using drugs. Mr. Beasley actually was relatively late. Most of the people that I sentenced who had substance abuse disorders were, 9, 10 when they started. New slide. So, where do we go from here? I want to talk about ordinary probation, and I want to talk about ordinary sentencing. I was looking for this presentation to see if anyone had done a study of bank robbers and the range of behavior with respect to bank robbery, and what would be how better to deal with bank robbers on one end of the spectrum, the guy without the gun versus the Italian job. For the sentencing guidelines, we treat them all the same. I'd love studies about what has worked in those programs. I'd like people to focus on that. I'd like to look at the role of age in the ways that we've described here. I'd like to understand criminal records. Criminal records which are disqualifying for drug programs are as easily a function of policing in certain communities of color, are as much a function of where you live. One of the men that I've talked to whose story rips me apart started dealing drugs at 14 because both parents were in prison. He had 3 siblings, and he was dealing drugs for school supplies. He wasn't dealing drugs to buy a Porsche. He was dealing drugs for school supplies. But by the time he got to 20, of course he had a record. He was essentially unhoused and lived on the street. He had a record. And when he got to before me, the sentence was a 10-year mandatory minimum. A 10-year mandatory minimum. All that I could do was write an opinion that says, this was absurd. This was ridiculous. And when he got out of prison after 10 years, He had a mark on his back. He called me once. This is long after he'd gotten out of prison when we were talking. He was driving on the Massachusetts Turnpike, and he got stopped by the police for going too slowly. He would tell me stories about when he got out of prison, he was told to go and look for a job in Everett, Massachusetts, a largely white suburb of Boston. He wasn't allowed to use a cell phone. They were not allowed. And he got lost. And nowadays there are no telephones either. He got lost. When he finally called back to the pre-release center, the person on the other end of the phone said, "I'm going to have to write you up for this. I'm going to have to write you up for this." The system has become so retributive at every stage that there was no help for him. This was really just, you stepped over the line, you're going to be punished. So he told me these stories. I was the sentencing judge. I had no idea. I had no idea. My job was finished once I said 10 years and I walked off the bench, I thought. But I'm meeting them now, and my job isn't finished, and our jobs are not finished until we use what we have been learning in these wonderful diversion programs to change the system from beginning to end. Thank you.